South Africa, ruling in Johannesburg, has delivered a clear message to employers. Looking for another job is not misconduct. The court found that Lucchini South Africa unfairly dismissed its safety, health, risk and quality manager Vishen Mahabir after accusing him of secretly pursuing work with a competitor and acting dishonestly. Both the CCMA and the Labour Court rejected those claims, confirming that employees are legally entitled to explore the opportunities while still employed. To unpack what this means for workers and employers, we are joined on the line by Michael Baigram, a labor lawyer. Michael, thank you so much for your time. I thought it was legal all this time until this court ruling that I am allowed as an employee to seek other opportunities while I am employed. Why was this not the case at Lucchini and they decided, no, this does not apply to you?
Well, look, let's go backwards a little bit. And I have employees speaking to me on a daily basis telling me that they've been loyal to their employer for many years and now they're being retrenched. And, what's going on? Why am I being retrenched? I've done nothing wrong. It's business. It's business as usual. And people need to understand that business is business. Now, what is good for the goose is also good for the gander. Every single employee in South Africa is encouraged to keep the files open on what their value is out there in the market. Every single employee is actually deemed to be looking around all the time. You can't rely on loyalty. That doesn't work at all in this modern economy. We got a modern economy here in South Africa, and quite frankly, right through, and I'm now a little bit old, but right through my junior years working for other attorneys, I was always watching adverts. We all do that.
Of course.
All of us. You think maybe my value is better somewhere else, or maybe my boss in another place will be more pleasant to me. And I want to encourage everyone that's listening to keep your mind open, keep educating yourself, keep upskilling yourself, and keep looking. Yes, it's great to be loyal, and it's the old Japanese contract of employment, where you go find an employer at the age of 16 and you retire at 65 and you get a gold watch. The modern world doesn't work like that anymore, and everyone is encouraged to upskill themselves, educate themselves, do well where they are working, do really well, so that you've got the skills and that you can then be of benefit to another employer. What the court was saying, our Labour Court, is what does that mean? That means that you're disloyal to your current employer? Well, that's nonsense. You find me one person, look at all your friends, all of them, they go online and they look at the job market.
Of course.
Everyone does that. And I would expect people to do it. People are normal and they want to better themselves. They want to better their family. And so the court endorsed that. Now, I must just tell you, yes, there are employers out there who are saying, if you're looking for another job, please come speak to me first. Please give me first opportunity. And that's fine. But to tell people that if they look, they're breaking the loyalty, and that's what happened over here. This employer thought that this was a breach of the loyalty between them, a breach of trust, they said in the court case. And it clearly isn't. We all want to better ourselves in every which way we can. Obviously not illegally and not dishonestly, but we want to better ourselves.
We're still in conversation with Michael Baigram. He is a legal expert here on the show, and it's always a pleasure to have a conversation with him. We're looking at your rights when it comes to, whether you are allowed to negotiate with a competitor while still employed with another employer. This, of course, following a Johannesburg Labour Court finding dismissal being unfair, I beg your pardon, for a previous employer. Let's take a break. We'll be right back.
The Upside, 1 to 4 p.m. Central African Time. With Tebogo Lekhuleni and Mosito. Only on Channel Africa. The African Perspective. 60 years of Channel Africa. Your trusted voice. Your African perspective. Into the future. Across Africa. communities rise with the promise of clean water and clean sanitation. The African Union's 2026 theme calls us to action.
It's about mobilizing real commitments, securing climate-resilient water and sanitation projects, and ensuring that water becomes a driver of sustainable development and prosperity across the continent.
A landmark moment, not only for Africa, but for the global movement for access to safe water for all.
Assuring sustainable water availability for every home, every village, every nation. This is the Africa we want.
Channel Africa, the African perspective.
We take no sides, none whatsoever. We are the upside.
We're 21 minutes in. Welcome back and thank you for staying with us. We have Michael on the line. He's our labor lawyer and we are looking at unfair dismissals based on the fact that we are, entitled, I guess, to explore other opportunities. But there is a case that went to the CCMA actually, and the Labour Court described the charges against this particular person as unlawful and that people are allowed to go and seek other opportunities. Michael, I'm actually embarrassed to even ask you this question, but I mean, people have gotten off of murder for reasonable doubt. So I'm going to go ahead and ask anyway. Is there ever a point where an employer can lawfully stop me from looking for other employment, not just based on loyalty, but perhaps there are contractual obligations, whatever those may be, that can actually stop me as an employee from seeking other opportunities?
No, they can't, but it's not open season. And so, you hit a raw nerve because in your contract, you'll probably find, and especially more senior people, restraints of trade agreements. So in other words, if I'm learning certain secrets of the trade, certain clients, knowledge of prices and that sort of thing, and I go to another employer and they're competitors and I say, listen, let me share some information with you from where I'm working now so you can see how good it will be to employ me. If your current employer finds that out, not only will they then dismiss you, but they'll probably take criminal action and civil action against you. So you've got to be really careful. I do have some people who say, and I've just had an estate agent call me and say, well, the opposition has asked him to come and he wants to take all his clients with him. And I said, no, that's illegal in terms of your contract. It's illegal in terms of our common law. We're a nation that actually likes fairness. And you don't want to go and steal that information. Likewise, there was a case many years ago of a pharmacist who had been accused of stealing a formula of a new drug that they were making, and he went and applied for the competitor's job. And the current employer decided that we need to check up about this formula and whether it had ever been downloaded on this pharmacist's own personal computer system, which it had been. They went ahead and dismissed, and they said, we didn't dismiss you because you are looking for a job or that you're looking for our direct competitor, despite the fact that we hate him. We dismissed you because you've taken a formula that's cost us millions to devise with your help, and you've put it down in your private computer, and now we're very suspicious and we don't trust you. So your question is a very sore one in the sense that people need to be careful that you don't be caught trying to sell yourself with information that's not actually yours and should be protected. And even if you haven't signed a restraint, you have common law. We have common South African law. You cannot steal private information from your employer. So if you both decide to go to a competitor's radio station and say, listen, we know all their secrets and we'll tell you all about it. Take us on that basis and we'll give you a taste of what it's all about, what they're doing and how they're doing it. You don't do that. You wouldn't do that. I know you wouldn't do that. But I'm saying...
No, we wouldn't do that.
We've got to be, but we've got to be careful what message we give to our listeners.
Absolutely.
Michael, employers need to know that there are repercussions to, making such decisions. Was there any compensation then due to the employer or employee rather, who was dismissed unfairly?
Yeah, well, there always is. And in this particular case, it was back pay and damages. We don't know if that's the end of the road, because there might be an appeal. They're still in, this is a new case, so we're still in the litigation phase. And from what I understand is that that employer is considering an appeal. I don't think it was a reinstatement, because obviously that employee didn't want a reinstatement, wanted to go and work for the others.
Yeah.
But there will be damages, yes, because first of all, there are legal costs, and you know that lawyers rip their people off, so you've got to be very careful of lawyers as well. And I've got to hide behind the mantle that I'm a lawyer, so I can't be defaming all the other lawyers. You know the old phrase, 99% of the lawyers give the other 1% a bad name. But there are enormous legal costs in running a case through the CCMA and then going to the Labour Court. And I must tell you, it takes years sometimes to get to the Labour Court. I'm not sure of the timing of all of this, but you can imagine the angst that that employee went through. You can imagine how much that employee spent, and you can imagine at what it's done to his career. It puts everything on hold. It's a terrible event. Labor law is very personal, and you know, one of our most valuable assets all of us own is our job. It's one of the most valuable assets.
Yeah.
And if you lose that, and especially in South Africa, where we've got a large unemployment problem,
Yeah.
you don't want your name to be smirched. And you know, when you litigate against a current employer or even an old employer, the message goes out to other employers saying, don't touch Michael Baigram, he's dangerous. And then I'm now desperately trying to run from pillar to post with my CV, trying to get a job, and everyone knows that I've sued my previous employer and I can't get a reference. So you can imagine the damages that happened over there.
Absolutely. The reputational damage, very, very hard to repair, especially in cases of this kind. And just to use this case once again, Michael, as an example, as I understand it, the charges were described as trumped up. So let's talk about that. Perhaps you can unpack what mistakes the employer made in handling this particular disciplinary process, because we could find that cases of this nature are actually more common than not.
Yeah, I think the real mistake made by the employer in this situation is trying to curtail the rights of that employee. And many employers do it. They try and curtail also what you do at home and who you mix with. And I mean, as in my practice at labor law for the last 40 years, I've seen the most weird intervention of employers basically trying to control your life and what you're doing. You know, you say, listen, I'm going away for the weekend into the mountains. I'm going to go and camp in my little tent and have a break. And they say, no, you can't. You need to be online, just in case we need you. Now, we have lots of those types of things. With modern technology, employers they almost own you. It's a sort of form of slavery. Apparently, it's the worst in America, because once you're working for someone, you're theirs. And they control you from the minute you arrive home to the minute you wake up. They got absolute control. They force you to keep your phone on. It's just unbelievable. So in this particular case, they saw that as a breach of trust. How dare he apply for a job somewhere else? That's really what they framed their whole case that way. What they could have done as employers, they could have actually exercised their right by going to the employee and saying, we've heard you've applied, that's your right, but we hope you haven't taken any of our private information, you haven't badmouthed us, and you haven't told them any nonsense stories. You know, but at the end of the day, they charge this employee for bull SHYT. That's really what it boils down to. It's an absolute nonsense charge at a disciplinary hearing. And I've seen lots of these things where I had a case recently where the employee's wife had gone to work for the competitor and they dismissed him.
Oh, no.
Because they said, what about pillow talk? And he said, well, I mean, are you now trying to control me through my wife? Yeah. We have settled it. He left because he couldn't trust them afterwards. And he left, but we settled the case and he was given 6 months' salary. And yes, indeed, he went to work for the competitor, but he wasn't planning to go. His wife was looking for a job. and she thought I could do the same as what my husband's doing, and she did do it and got a job. And on that basis, they started attacking him and brought him to a disciplinary inquiry. I did step in and I said, but I mean, this is sheer nonsense. You can't control people's lives. If I want to go and interview somewhere, I'm going to go and interview somewhere. And if I don't want to tell them, that's my right not to tell them. That was another complaint they had. They said he did it behind their back. Well, what do you think? He's going to go and tell them, announce to everyone that I'm going for a job interview, and then I don't get it. And then everyone hates me.
Michael, we're going to have to park it there for today. Thank you so much for your time. I think if anyone needs your assistance, they can just check you out. Google your name, Michael Baigram. He's a labor lawyer. Again, confirming that looking for another job while you're employed is not misconduct, nor is it illegal. It's 31 minutes after 1 p.m. Central African time. Let's get the latest sports.
Sports.